Buying a house that they can call their own is a dream of every Filipino. They work hard in order to save money in order to buy their dream house. However, some have become victims of double sale transactions wherein two buyers who bought the same item as defined by Article 1544 of the Civil Code of the Philippines. Last month, real estate developer Delphin Lee was arrested after evading arrests from authorities since 2009 for numerous cases of syndicated estafa filed against him for allegedly committing double sale transactions and for deceiving the Pag-ibig Fund into releasing loans for Globe Asiatic property buyers. Recently, the Senate probe by the Committee on Urban Planning, Housing, and Resettlements started with members of the Pag-ibig Fund and several victims of double sale transactions providing their statements. As time progresses, the cases filed against Delphin Lee has sparked awareness and curiosity from individuals who seek to purchase realty properties. The questions now are, what does double sale mean? How can a buyer prove that he was a victim of double sale transactions? What kind of evidence does he or she need? If found guilty, what penalties will double sale sellers face?
Good evening. You are watching Legal Help Desk on the Solar News Channel. This show is about making the law work for you by giving legal advice on topics that matter to you. I'm Attorney Karen Jimeno.
And I'm Attorney Rod Nepomuceno. Tonight, in light of the Senate probe on Globe Asiatic's President Delphin Lee, we will discuss your legal rights on the issue of double sale, what you need to know about double sale, and what you need to do should you become a victim of it.
Our guests for tonight are Attorney James Heffron and Attorney Ed Chico, professors at the De La Salle University College of Law. Good evening and thank you for being with us tonight.
Good evening, attorneys.
Yes.
Good evening, good evening.
Good evening,
Ed, and welcome back.
Good evening. Welcome back.
Yes. Well, obviously, as we mentioned in the introduction, this is a very timely show that we're having, an episode on double sale, no? In light of Globe Asiatic. But before we go into the details of that, in fact, we can't go to the details of that because it's a pending case. But however, we'd like to do this show in light of to try to protect
or basically, just to show the viewers that one, this problem of double sale happens a lot. It's a risk that is really out there. And even apparently, even if you buy from a government-owned corporation, GOCC or government agency, there are still risks when you buy property. So I guess we start off by defining what is really double sale.
I mean, what is the definition of a double sale?
Siguro, Rod, before we discuss what double sale is, it's important for us to understand first what a contract of sale is.
Yes, okay, yeah.
A contract of sale under the Civil Code takes place when the seller obligates himself to transfer ownership of and deliver a determinate thing to a buyer who in turn obligates himself to pay the purchase price. So from the definition, you can sense that a contract of sale is consensual. So meaning, by mere verbal agreements, both parties can perfect a contract of sale.
So
you don't even you don't even have to reduce it into writing.
But this is something I guess we have to clarify. You know, normally if you buy property and they say, but we have no written contract for that sale, is it really valid for the seller then to say that it was not a valid contract because wala naman kaming kasulatan eh?
Ayun nga, I'd like to clarify that that is not the case. It is essentially consensual.
But
so if
what
there's
about,
meeting of minds, then that is sufficient.
What about real property?
Ayan. Now, when it comes to real properties, for example, bumili ka ng parcel of land. So you need to reduce it into writing. In fact, you have to contain the same in a public instrument. Not necessarily to bind both parties, but to protect yourselves against third persons who may be interested in the same property.
But isn't there, attorney, also a provision in the law which says that for real property, meaning for land, house, and lots, you really have to have a written contract or else it's unenforceable?
Correct.
Yeah, that is true. But according to the Supreme Court, there is a perfected contract in the sense that both parties have agreed to it. So there's a meeting, there's this meeting of minds because that's the operative phrase. But at the end of the day, if it concerns real property, you really need to reduce it into writing and you have to contain it in a public instrument, not only to make it enforceable, but more importantly, to protect yourselves against third persons. And this is where kasi the issue on double sales will come in.
Siguro we
Okay,
have to
so-
clarify, public instrument means notarized.
Notarized,
Notarize yung contract of sale.
Ideally, yun nga, for you to be able to enforce it vis-a-vis or against third parties. Pero between the two parties, it's valid.
It's
Kahit
valid.
na verbal yan, di ba?
Only you cannot transfer ownership.
Correct. That's right. So I want to clarify that there is a sale. There is a sale naman. Even pag real property, there is a sale. Yun lang nga, you cannot enforce it against third parties and you cannot transfer it or register it if there's no legal document. All right. So let's go naman to double sale. Double sale tayo. Maybe let's do, is there a difference, James, between double sale sa movable property and immovable property?
Yes, that's right. Now, there's really a difference because first, let's go to movable properties. As we know, movable properties are those properties which are not land, okay? They're not houses, they're not buildings. Examples of movable properties are vehicles, for example. No? When it comes to movable properties, the rules are different. There is double sale when in fact you have one property which is in fact sold to more than one person. Because as the law provides, you can only sell one property at one point in time, at a given point in time. You cannot sell it to different people at different times. So when it comes to movable property, the rule really is whoever has first possession, okay? Whoever has first possession, then title shall be given to him. Now when it comes
That's the presumption.
So,
That's the
kunwari,
presumption,
just as an example, if you have a car,
Yeah.
and then I sold the car to Rod, and then later on I sell it, the same car to Attorney Ed, whoever
has the first possession
gets
of
the
that.
car first.
Yes.
So, if, for instance, even if nauna kong ibenta kay Attorney Rod,
Tama
pag
yan.
nakuha agad ni Attorney Ed ahead of Attorney Rod, Attorney Ed will have
The presumption.
The presumption that he has the ownership of that property. Now, when it comes to real property, the rules are quite different, no? Because as far as real property is concerned, you have the so-called torrents title, the registration of the property before the registry of deeds. And the best evidence really of title to property is the transfer certificate of title. So when it comes to real property, the first person who registers it, who acquires it in good faith and registers it in good faith, is the person who will be given ownership to. And then if we don't have that, then it will be first in possession. That's where possession comes in.
So first, registration in good faith. Importante pa natin good faith.
Acquisition. Actually, it's acquisition in good faith.
Acquisition in good
meaning
faith.
you don't know of any defect na hindi
That's
mo
right.
alam na nabenta na sa iba pang tao.
That's right.
Or,
That's
okay.
correct.
Yun yung first, yun yung first rule when it comes to immovable properties. Acquisition in good faith
Correct.
first.
And then registration in good faith.
In good faith, yung second. Kung in
That's
other words,
right.
if you can't determine who acquired it first talaga,
Possession, dun papasok ang possession.
possession.
That's right.
Okay.
Now, when you mentioned na there has to be two sales in order for there to be double sale, I guess this is when we clarify kung what first sale is considered as valid. Because I've read other Supreme Court decisions wherein pagka void yung first sale, meaning there's a defect in the first sale, there's really no double sale because it automatically goes to the second buyer or to whoever na valid yung
That's right.
contract of sale. So, what types of sale are considered as void or hindi, or basically
It's a good point. Yeah.
pagka non-enforceable buy. For instance, if I buy land from Rod and hindi ko sinulat in a contract, and then Rod later on sells the same parcel of land to Attorney James, pero meron silang written contract, would Attorney James have a prior right than me?
Yun nga yung sinasabi natin doon, Karen. If you are the first buyer, you have to make sure that the contract of sale is contained in a public instrument, because if not, you cannot protect yourself against third persons. So in the meantime, if the seller would like to sell it to another person, and that person, although he is the second buyer, is able to proceed with the subsequent registration of the subject property, meaning the agreement is reduced into writing and subsequently he conforms or he complies with the requisites for registration, then he is entitled to the item. Kaya nga the moral of the story here is, if you're the first buyer, make sure that all the requirements,
Or properly met?
yes, exactly.
What if nag-down payment na ako?
Even
Is
if
that still
that-
something I can raise and say, I should get the land ahead of you because I already gave a down payment?
people should understand that the down payment given, or even that the delivery of the property, is not an element of a perfected contract of sale. So for as long as there's meeting of minds, there's consideration, there's object, and if it's a real property, it is reduced into a public instrument, then that's the time you can be protected. Kahit na bayaran mo pa ng buo yan. Kaya nga ang moral ng story dito, kagaya sa pag-ibig, hindi ba? Hindi porket nauna ka, ibig sabihin sa'yo na. So you have to make sure that if you're the first buyer, you comply with all the requisites.
So hypothetically speaking, no, if let's say we had a transaction, I sold you my property verbal, and then maybe I gave a down payment. Then I sold it to James, all right? Pero may ano naman, may document, di ba? If later on I go to a case and file a case, right? And as it turns, or you file a case, and I admit that yes, we had a verbal agreement. The court will acknowledge that. No? Will recognize that verbal agreement ahead of that.
Yeah.
Kasi there was a meeting of minds.
Yes,
Kasi
that's-
you didn't
yes,
dispute
yes.
it. You didn't dispute that
Okay.
there was an agreement.
Okay, that's precisely the point, because when you talk of double sales, you're talking about existence of two valid contracts of sale, except that the issue is who should be entitled to it. So if it's a real property, if you're the second buyer, kahit subsequent ka lang, but you're able to register it in good faith, and we have to actually emphasize on that phrase, good faith, it's yours. The thing is, what if you are the first buyer? What is your remedy? Of course, there's a contract of sale between you and the seller. So when you go to court, it is tantamount to breach, for example, because there's already a perfected contract of sale.
Breach of
So you can
contract.
ask for return of the money, or even you can ask for damages if warranted.
So but you can't get the property.
But you
kasi
can't
there was
get
a
the property.
Oh,
Yun yung issue ng double sales.
All right. Okay. So now, how do you define? We always keep saying the word good faith. No, we qualify good faith. How do you define good faith?
Actually, good faith, there's really no hard and fast rule when it comes to good faith. It really depends on the circumstances of the case. Well, Supreme Court has time and again defined, it depends really on the facts of the case, but the Supreme Court has stated that good faith really, it's that diligence or precaution that a reasonable man, a man of ordinary prudence would take in light of the circumstances.
Yeah.
So that is good faith.
I'd like to give some examples here because I was teaching sales in UP College of Law before. So several decisions of the Supreme Court would give examples. Kunwari, there was a transaction before where there was a double sale, and then the second buyer said, no, I did not know that it was sold before. But then when they actually looked at the facts, in fact, there was already someone living there. So the court was saying, you can't claim good faith because only, like, even if you exercise ordinary diligence, imposibleng bibilihin mo yung lupa without even looking at it.
Right.
And if you only went to look at it, you could see na may nakatira na doon, which would have asked, if you were a diligent person, at least, ordinary diligence, you would have at least asked, anong ginagawa mo dyan, sino ka?
There should be a red flag.
Oo,
There's a red
diba?
flag there.
Exactly.
No? So that means you can't claim good faith anymore. Kasi, yun nga, I guess caveat emptor applies only when in a situation where you were able to exercise due diligence. All right.
Actually, tama si Attorney Karen but a distinction kasi should be made between a buyer in good faith and a registrant in good faith. So a buyer in good faith, for example, is someone, if there's a title, he doesn't even have to go beyond. All he has to do is look at the title. If there's nothing wrong with the title, there are no annotations, then you're a buyer in good faith. Ang problema lang, are you a registrant in good faith? That's a different thing. For example, buyer in good faith ka, nabili mo na yung lupa. You are now supposed to proceed with registration. And you discover subsequently na may nakatira, someone is in possession, you discover subsequently that the property was actually previously sold to another person, then you're no longer in good faith.
Okay.
Because good faith should begin from the time you purchase it up to the time that you register the same.
All right. That's great. So we have some questions naman from our viewers. Let's answer these with the help of our guests, of course. Letty sent us this question. I have partially bought a parcel of land and discovered it was being sold to another party. What shall I do now? All the conveyance was unregistered at the registration of deeds.
Okay, so Attorney James, parang partially bought.
partially
How
bought.
Partially bought, what does that mean? Of course, we have to see, is there really a contract of sale? Is this a contract to sell? So we have to determine what is that. Now, before I go into that, I think there should be a distinction between what a contract to sell is and a contract of sale is. Now, when we say a contract of sale, there is already a transfer of the ownership of the property because presumably payment was already made. As far as contract to sell is concerned, there is no transfer of ownership yet
Suspended.
because it is suspended by the installment payments. Okay? In this particular case, let us presume that there was really a contract of sale. Okay? But I think when you say when this
Partially
person says partially bought, was it the
Siguro na
Baka
may mga
partially
payment.
paid?
binabayaran
Binabayaran
pa.
pa yan?
But
Yeah.
I guess we have to clarify here that even if you promise, you bought a property and you haven't paid yet, kahit wala ka pang binabayaran, if the deed of sale says that there's already sale of the property or transfer of the property, then in spite of the lack of payment, it's already a completed contract of sale.
Actually, you
So,
call that a deed of conditional sale, which is actually different from a contract of sale. Because when you say it's a deed of conditional sale, ownership has already been transferred, but it's possible that there are certain conditions that haven't been met yet.
Kunwari
Like, for
full
example,
payment.
full payment.
Yeah.
No? In this case, siguro, ang nangyari dito, there's already a transfer of the ownership, pero hindi pa nababayaran in full. And then I think it was not yet registered because the problem says na wala pang registration. No? So in this case, if there was in fact a double sale, then the rule should apply. So
Meaning?
siguro, ang mangyayari, who first registers is in good
no,
faith.
he was saying wala pang nag-register.
Wala pa kaya nga,
But
no?
he
So-
said, I think what he found was that binibenta.
Binibenta.
Binibenta pa lang yung property.
Kung ako sa kanya, dapat siguro pa-register niya na. No,
If it was lalo na if it was a contract of sale.
If there was already a contract of sale, no?
Yes.
So kailangan pa-register na yun para at least to protect her rights.
So again, if the televiewers didn't catch that, iba yung contract of sale and contract to sell. Okay, so with contract of sale,
Ipa-register
title is
niya
already
na.
transferred and you can register the title already.
Pero kung contract to sell pa lang yan, it's either he can go after the seller to enforce that contract to sell or I guess bayaran niya na para malipat sa kanya yung
But if I may
property.
add, Rod, no?
Yeah.
Again, we have that contract of conditional sale, which is
iba pa
different
yan,
from
it's
the two mentioned earlier. No? Because in the contract of conditional sale, as we said earlier,
There was a transfer already.
there was already a transfer of ownership. Yun nga lang, merong mga
May
certain
conditions.
conditions na hindi pa na-fulfill. No? Like
Alright.
full
Okay.
payment.
Okay.
We have another question from Alan and he's asking, I purchased a land and paid it at the national mortgage. However, when I did a follow-up regarding the issuance of the title, I was informed that the land has been purchased in full payment by another person. I paid in July. The other person paid in June. It was revealed that we're talking about two different places but have the same address. How come we have the same address but different land locations? I was told that it was a double sale. Will I still be able to get my own title?
It's a little
Parehong
bit complex.
address, pero
Yeah.
parang when they're clarified, it's
Yeah.
located differently.
Yeah.
So, saan dito perhaps yung mistake?
I guess if that is the case, they will simply have to clarify. Because from what I see, they're talking about two different subject properties. Because yun yung kwento niya di ba? It's just that they have the same address. So if that is the case, it's just a matter of clarifying the same. Because if it can be proven that what should be involved here are two different properties, then you're not talking about double sales. Because double sales should presuppose that they have the same subject property. So that should be clarified first. Baka nagka-problema lang. You have to understand that sometimes they work on so many things, they process so many documents, and that mistakes like this are likely to happen. So probably he has to clarify first. Kasi nakikita ko
Saan siya
ibang
pupunta
properties
dapat?
eh.
Register
Register
of
deeds.
deeds? Or
Well, I
sa...
guess he has to go to the NHA first because if it's an NHA registered land in Antipolo. But if that is the case, of course, he can also go to the Register of Deeds and find out. Baka nagkamali lang sila ng pagkakasulat ng sa titulo. Baka nga magkaibang properties yon. So there's no problem. But
And if
assuming
he
if this-
finds out na may double sale,
Yeah, but assuming for the sake of argument, we're talking about the same property, then the rules on double sale should apply. So the first is able to register it in good faith will be entitled to it.
Good faith naman. All right. Next question is, Mario shares with us, my mother bought a lot in the year 2000 for 1.2 million pesos. No formal deed was given to her as they agreed to pay the price in installment. When the original lot owner died, we continued to pay through his daughter, or to his daughter, I guess. However, his daughter sold the same lot through a deed of sale without our knowledge, causing the old transfer of certificate of titles cancellation. The new owner last year sent a letter offering us, the earlier buyer to vacate the premises. What should we do to settle the problem? Okay. This seems like a double sale case. No?
It is clearly a double sale case. So in this case, we apply the rules again. Who first acquired it in good faith, okay, and who first registered it in good faith. In this particular case, I think no, there was a problem here as far as the daughter is concerned because the daughter supposedly was the one who continued get payments no,
receiving
from
payments,
the from the buyers. No? So ang analysis ko dito, yung daughter mismo did something misrepresented, no, and did some fraudulent thing to sell it to another seller. I'm sorry, to another buyer. Again, but in this case, no, we have to apply the rules, as I said a while ago. So sino nag-acquire here in good faith first? Sino ang nag-register first in good faith? So those rules will answer that particular problem.
All right. Okay.
And it's not a defense on the part of the seller na yung dito parang yung kamag-anak nila was the one who fraudulently sold the property.
Yes, because of course,
Namatay ni owner.
even if daughter yan, no, kailangan dapat meron pa ring special power of attorney, for example, for the daughter to be empowered to actually transact the transaction. No? So these are the things that we have to look into.
Definitely the earlier buyer, the one who asked the question, has the right to investigate all of that.
That's right, that's right.
All right.
Okay,
Okay.
very helpful. We'll take a short break for now. Legal Help Desk will return after these messages.
When faced with a double sale case of immovable properties such as houses and lots, there are a few rules that need to be addressed by the buyers as stated in Article 1544 of the Civil Code of the Philippines. 1. The first registrant in good faith. This means that whoever registers the property first and without malice shall have the right over the property. 2. Should there be no entry, the first in possession in good faith. This means that whoever has possession over the property first is the rightful owner. 3. In the absence thereof, the buyer who presents the oldest title in good faith. This means that if the two buyers were able to register the property in question under their name, the buyers are then required to present the titles to check who among them registered the property first. Another thing to note is the differences between a contract to sell and a contract of sale. If the seller gave you a contract to sell, this means that the ownership of the property is still with the seller and has not yet been transferred to any of the buyer until full payment is made. If the seller issued you a contract of sale, then the vendor or seller loses ownership of the property and has transferred it to the buyer. Always check with the Register of Deeds if the property you are planning of getting is being registered to the buyer and that no one else is registering to own these properties.
You're still watching Legal Help Desk on the Solar News Channel. And we still have with us Attorney James Heffron and Attorney Ed Chico of the DLSU College of Law.
Ayan. So, we're talking about double sales, and we want to find out now, I guess discuss in the second gap, remedies and penalties, no, for people who may be guilty. So, first, let's start with remedies. Ano yung remedy of
Let's start
anyone
with
who's...
land first, house and
Yeah,
lot. So
the
if,
house and
for
lot, yeah.
instance, you find out that the land you bought or the house and lot you bought or the condominium you bought was already previously sold to someone else or was subsequently sold to someone else. What can you do?
Well, ang issue nga dito, di ba, when you talk of double sales, the issue is who is entitled to the item. So if the second buyer is entitled to the item because he's able to register it in good faith, so there's no problem as far as he is concerned. Kasi nakuha ko na yung item eh. But the question is, what about the first buyer who is deprived of the property? Are there some remedies available to him? Of course there are, because we have to take note that when you talk of double sales, the contract of sale entered into between the first buyer and the seller is essentially valid. So if he's not able to get the property, then definitely he can sue the seller even for estafa. And that, of course, is criminal in nature. And when you commit a crime, you commit it against the state. So all he has to do now is go to the fiscal and file his complaint. There will be determination of probable cause. There's a preliminary investigation. And if there's probable cause, there will be an information that shall be filed before the court. And the case now will prosper. So criminal yon against the seller. I just would like to harp on that. Akala kasi ng mga seller, if I engage in double sales, the liability is basically civil in nature.
oo.
Of course, he can be held liable civilly, but he has to take note of the fact that he can also be held liable criminally.
Now, we've been discussing na kung sinong mauna mag-register, yun yung may right doon sa property if it's sold twice. What if, for both buyers, at the time that they find out that there's two buyers, that there's two of them, what if they haven't registered at the same time? So hindi pa nare-register yung property. Who will have the better right to the property?
Well, in that case, kung alam na nila pareho na may sale na nangyari, so baka mahirap nang sabihin na may good faith sila pareho. Okay? So there's actually a third rule.
Third rule, oh.
Who can actually prove oldest title. No? Yun yung sinasabi. So ang titignan natin dito, kanino unang binenta yung property? Who acquired it first?
So we'll
in good
compare the
faith?
deeds.
We will compare the
The
deeds.
deeds of
So
sale.
earlier in the sale, no, kung sino yung unang pinagbentahan, siya sigurado ang makakakuha.
Pagka naman, other than that, there's also another rule, right? That whoever took possession of the
That's right.
property
Yeah.
first.
It presupposes, of course, that both parties are in good faith. I mean, when you take possession, you are in good faith. For example, I'm the second buyer. I purchased something, and then nobody is in possession. I took possession in good faith, not even aware of the existence of any defect in my title. Then if that is the case, then I am entitled to the property because there is no registration. So parang alternative yan eh. It's not like you can choose. I register or I possess.
And then,
So in the absence of registration lang.
what about remedies if there's a double sale of movable properties, meaning either cars or even jewelry, yung mga movable items?
Well,
Ano yung mga remedies doon sa mga ganun?
Well, unang-una, ganun din. Kagaya ng sinabi natin, whoever takes possession in good faith, madalas mangyari yan sa magkaibigan, if I may explain. For example, I sell my pair of shoes now to Rod, who is my friend. For example, he's so busy, he tells me, o sige, deliver it to me na lang after 1 week because I'm so busy now. And in the meantime, I
Pero
decide...
may meeting of minds na yun.
May meeting of minds na, there's a perfected contract of sale, it's consensual. But in the meantime, before the lapse of the 1 week period, I decide to sell it to someone else.
James comes in.
Oh, James comes in, nakita mo, suot niya. So question, who is entitled to it? It seems to me that James, since he is the first person who acquires it in possession, in good faith, then he is entitled to it. Ang remedy mo, you can now sue me. You can sue me for breach of contract because a contract presupposes the obligation to deliver. I cannot deliver anything to you, so you can sue me. You can even rescind the contract if you want because I'm not able to comply with my obligation to deliver and you are ready to pay.
Yeah.
Or perhaps you can even sue me criminally. Diba? Because essentially that thing is being held in trust for your benefit. Sa'yo na yun eh. I am just keeping it for you.
So I'll sue you for estafa.
Exactly. You can
Attorney
sue
James,
me for
what
estafa.
if hindi pa bayad yung property? Because some people, they use that as a defense. So yung mga, for instance, in that example, yung shoes, what if Attorney Ed says, hindi pa naman ako binabayaran ni Rod eh. Is that a defense? And then, obviously, hindi ka makaka-file ng case for reimbursement. What case can you file in?
That's a question nga. So titignan natin dito, meron bang perfected contract of sale between the first buyer and the second buyer? No? As we said earlier, is payment really a necessary condition for ownership to transfer? In this case, meron ng meeting of the minds between Ed and Rod. No? Yun nga lang, hindi pa bayad, no? Hindi pa fully paid. Pero in the yung second buyer already had possession of the property. So we have to stick to the rules. No? The rules say who has the first possession would actually be the one who will be the owner of that property. Doon sa movable
And then
property.
you can also file a case for damages dun sa seller kahit
Against
wala ka pang binabayaran. Kuwari, Rod
I can
hasn't
file
paid
a
for the
case.
shoes, pero gusto niya talaga sana yung shoes na yun. You can file a case for
Special
damages.
choose ni Ed eh. Special. So I wanted it talaga.
I think the question many of our viewers siguro would ask is, can the first buyer recover the shoes from the second buyer, notwithstanding the fact that the second buyer is in good faith? So he can't. No? He can't do that. No?
Cannot.
The remedy really is against the seller himself for misrepresenting and saying that he can actually sell these shoes to the second buyer. No?
And Rod can also file a case for damages.
But-
Kasi some would
exactly.
say, bakit mo ka dedemanda, hindi ka pa naman nagbabayad?
Totoo yan.
But if I may say, we should point out, we should really clarify that payment is not an element of a contract of
That's
sale.
right.
Yeah.
So if there's a perfected contract of sale, even if you haven't paid yet, di ba, you are still entitled to the delivery of the item,
Yeah.
except that when it is delivered, the seller can demand payment from you. And if
That's
you
right.
couldn't pay, then that's the time the contract may be
Be rescinded.
canceled.
That's right.
Pero may kontrata na.
Okay. All right, we still have some questions from our viewers. We'll continue to answer them with the help of our guests, of course, starting with April, who sent this question. We have been occupying a lot for almost 67 years, having improved and maintained this under a jurisdiction of a presidential proclamation lot. Our problem now is that a certain family is now trying to sell the land, saying that they own the lot and claim that they tax declared the land. Do they have the right to claim this lot that we had been occupying since time immemorial? Well, not really time immemorial, 67 years.
6-7 years. That's more than the 30 years prescriptive period, no, provided for by the law, because the law specifically states that if a person has been occupying a piece of land for more than 30 years, then that can ripen into ownership. I assume in this case there are no titles. No?
Presidential, ano,
It's by basis of a
declaration
or proclamation. No? And this was sold, supposedly, they find out that it was sold to another
party is trying to sell it. Another party is trying to sell it
yeah.
to a third party.
However, there's a tax declaration involved. So the tax declaration, absent a transfer certificate of title, can be a evidence of ownership. But we have to take into consideration here the circumstances behind the case. So even if the second buyer supposedly has a tax declaration, what if the tax declaration was acquired in bad faith? So again, the element here is good faith. Who first acquired it in good faith?
At saka meron uninterrupted possession 67 years.
67 years. No? So
I
that
think
in itself
that
is rather
itself would
strong.
probably be the more important question.
Kasi nga,
Yes.
payment of tax is merely indicia of ownership.
Yeah.
It is not automatically tantamount
Correct.
to ownership. Kasi some people have this idea, I've been paying the real estate taxes, therefore I own it. Not necessarily. You have to consider other facts.
Okay.
Okay. Then we have another question from Ben. We are selling a piece of property for 7.5 million pesos. Our broker has advised us to make a deed of sale for 7.5 million pesos, which will be used for the actual sale. But he also advised us to make a second deed of sale, one that only indicates a sale price of 2.5 million pesos. He said that 2.5 million pesos is the market value of the property and will be used for the capital gains tax payment. He assured us that this is legal. Is it legal? What should we do to avoid double sale? So it's actually very unusual. Dalawang pinapa-execute sa kanila. Deed of donation and deed of sale.
very
Magkaiba pa yung
dangerous.
amounts. What would you warn
Actually,
this person?
I think what they want to do is they'd like to enter a simulated contract in order to avoid certain tax consequences.
So malaking donor's tax siguro.
For example, when you sell something, the capital gains tax is automatically 6%. And it is based now on the purchase price as indicated in the contract of sale or the fair market value, whichever is higher. So kaya nga kung magkamisan, if the fair market value is 2.5 million but you sell it for 3.5, sometimes what they do, the contract so stipulates that it is actually only for 2.5 million so that less tax will be paid because under the NIRC, it is the seller who is obligated to pay for the capital gains tax unless, of course, it is so stipulated otherwise.
So in this
So in this
case,
case,
obviously since they were being asked to execute two contracts to avoid certain taxes, is that...
That is
is
definitely not
illegal,
legal.
right?
No?
Oo.
Hindi pa pwede mangyari yun because we have to pay the proper taxes.
If ever one of the contracts would be rescinded or would not be deemed valid.
Actually,
I mean, one would probably be valid.
Hindi, tama yun.
That's right. No?
Hindi, tama yun. Of course, the BIR will determine which of the two contracts
more beneficial for them.
more beneficial for them. And then it becomes the contract between the parties because it can happen that it is actually a case of the nation. The problem is you pay more.
Yeah.
So
Yung
sometimes,
donor's tax is higher.
yeah, it's higher as a rule. May graduated din yung rates eh.
Pero-
But at the end of the day, let's just make it a contract of sale nila. Or sometimes naman, they do that, lalo na pag magulang at saka anak. Because you cannot donate to your son. Hindi ba? And besides, it becomes his advance legitim then, assuming you can donate to the son. So what they do, so that the other siblings could not go after the property, they make it appear that there is a contract of sale entered into, but at the end of the day, the son could not actually pay for it. So it is simulated. So that's why we have to harp on that. Ibig sabihin na simulated, hindi talaga yun ang kontrata nyo. Either wala kayong kontrata, you make it appear that there is one, or that is not really the contract intended. At the end of the day, it might just be a contract of donation.
Yes.
So in that case, the BIR can run after you. Lalo pa ngayon,
Very strict ngayon.
napaka-strict
Strict,
ngayon ng ating
Okay,
BIR
so
commissioner.
Ben, don't
do it.
agree to have two contracts. Mag-decide ka, do you want a deed of sale or a deed of donation? But to also answer your question, at this point, wala pang double sale.
Yeah,
Kasi
wala
hindi pa naman, and having two contracts naman is
Yeah,
not
yung question niya
double
nga is-
sale, basta same person. Basta you have to decide, whether hahabuli kayo ng BIR.
So yeah, in question, is it legal? Yeah, no, it's not legal. It's
not legal.
Okay, so,
Don't do it.
Don't do it. All right. So next question, Weng shares us this question. My mother bought a lot in 1994. We have land declaration and paid taxes for 20 years. Our problem is that there's an ongoing construction of a subdivision in the area. We were informed that we will have to leave our property as the lot has already been purchased by the developer. The developer offered 75,000 pesos to us if we will vacate the house. Do we have a case if we will sue the developer?
Yes, definitely. Definitely, there is a case, no? Because well, they have been paying. They have been paying the
declaration.
tax. There's a tax declaration. No? They have been paying the taxes. But I assume here there is no title yet.
Parang
No?
wala.
Parang wala pang title. So in this case, they have acquired it in good faith, although they haven't registered it in good faith. Now we have to focus now on the developer. Was the developer in good faith or in bad faith? So if the developer is in bad faith, then definitely the first buyer can
Saka
sue the
if they
developer.
were staying there, then the developer could be considered in bad faith.
Yes. As a matter of fact, when it comes to good faith, we also have to focus on who is exercising that good faith, because there's a difference. If the person exercising supposedly good faith is an individual, then the rule is that individual doesn't really have to go beyond the four corners of the title. So kailangan lang niyan tignan yung four corners, pag may mga annotations doon, etc., etc. There are red flags there, no? But if the person supposedly or the entity supposedly exercising good faith is a corporation or a bank, for example, they have the resources, they have deeper resources. So they are required, the Supreme Court has said in so many cases, to go beyond the four corners of the title
I see, okay.
and look at certain red flags. They have to investigate if, for example, in this particular case, the land in question is being possessed by a certain family. So they have to look into that. Why is it like that? So failure of which may be construed as bad faith on their part. So definitely, the first buyer can sue here.
All right.
Okay, we have another question from Jean. My uncle has an NHA registered land in Antipolo. However, the homeowners association said that his ownership has been forfeited as he failed to render monthly fees. The association also said that the land has been acquired by another homeowner and my uncle doesn't have any right over the land since he does not have a TCT. Is there any possibility that my uncle will get his land back? What does that mean, the NHA registered title?
National Housing Authority.
I guess this probably may be under the program of the NHA, if I'm not mistaken. Although the facts are not that complete, no. But I would assume that this is a low-cost housing program wherein the supposed buyer will be buying property and then it will be funded, no, by a government agency. So again, in this particular case, we just have to stick to the rules. No, we have to see who acquires it in good faith, okay, who registers it in good faith, and we have to determine. If we determine it through the rules, then we will get the answer to
But
that.
tama ba yung riniraise dito na defense naman nung, I guess, the seller or property developer that he lost his ownership when he failed to pay the monthly fees?
Well, actually, ang tingin ko dito, he's talking about the monthly fees supposedly given to the homeowners association. Under PD 957 kasi, if there's a subdivision, there will always be a homeowners association, the purpose of which is basically to take care of the subdivision. So yun ang, they are in charge of security, paying for certain obligations, emanating from the taking care of the subdivision. So in return, each member of the homeowners association or the unit owner is supposed to give his contribution. So it is the contribution given to the homeowners for purposes of looking after certain obligations in their role of looking after the subdivision. But at the end of the day, if you cannot pay, that will not mean forfeiture of your property. So the cause of action of the homeowners will probably to sue you for collection of sum of money.
Collection of some money.
Because the obligation has nothing to do with ownership.
They cannot just grab
Oh,
that
they
title
cannot just
from you.
grab it just because you couldn't pay for it. Hindi ba? So iba yun.
Yeah.
Oo. Thanks for clarifying that, Attorney Ed. So, in this case, at least we can tell Gene, sa uncle niya, that he should investigate na it's really not the failure to pay the monthly dues, but whether nasa kanya ba yung title from the start and kung binenta ba ulit yung lupa, right? Okay. Sige, thank you so much. And before that, we'll take another break. We'd like to thank our guests, Attorney James Heffron and Attorney Ed Chico of the De La Salle University College of Law, for joining us tonight and discussing the issue of double sale. Thank you, gentlemen.
Thank you very much.
Thank you very much. Thank you.
Legal Help Desk will return. Keep it here on the Solar News Channel. Welcome back to Legal Help Desk on the Solar News Channel. And today we had a very important topic,
Discussion,
which
yeah,
is
that's right.
double sale.
Very timely.
Yeah.
In light of what's happening, of course, everyone knows the Globe Asiatic case. But yeah, it is very timely. And
Yeah.
maybe
And
we
it
can
happens all the time. This is the, I think, most contentious part of our sales law, because normally, if you buy property, there's always a risk that either it has been sold before or that it might be sold again. So for those buyers out there, I think an important lesson we learned today is that when you're buying property, be sure to check first. So one of the things that I think helpful tips here, what you can do is first, get a copy of the title. Yung certified true copy ng title, just to make sure na tama yan. And you can do that by just going to the Register of Deeds of the place where the land is located. And then make sure to check the title. Tignan nyo kung merong annotations. Annotations mean na pag nakita nyo yung title, meron sa likod yan, yung blank space. Tignan mo kung may naka-register na prior sales or kung naka-mortgage ba yan. Because then, that's really the indication of good faith na pag nakita mo yung title, kung meron bang nakalagay. Kung wala, then that's a defense for saying that you're in good faith. And then, of course, if you have time, it's very important also to go and look at the property. Because yung mga red flags dyan, pag meron ka nakitang nakatira, tanungin nyo, binili nyo ba yan, or caretaker ka ba for someone else? Because these are the things that you need to establish in order to be considered a buyer in good faith.
Yeah. So important, no? Yung unang nakaka-acquire, and then of course, who first registered it, okay? And then who has possession, and then the one who can show the oldest title. Yun ang normally the proof, no? Na yung parang hierarchy, so to speak, na unang check ng courts. Now, if you are, let's say, the earlier buyer, and you claim to be the earlier buyer, and there was another buyer who is able to get possession of the property, what are your remedies? Let's say that that second buyer nga was able to get it in good faith. What are your remedies? The remedy there is not really to grab it from the second buyer. Kasi buyer in good faith nga, no? And you weren't able to, I guess, finalize your title and register your title. So that your remedy there is to really go after the one who sold it to you, and if you can prove bad faith, you can actually even file a criminal case of estafa. And that's medyo matindi yun, no? But you can also claim for damages, and of course, claim whatever you've already paid. So yun yung mga remedies that you can have.
And just a reminder to the buyers out there, lalo na if you're buying land or house and lots or a condominium, make sure that the deed of sale is in writing. Don't rely on just a word of mouth or an oral agreement. And then have it notarized. And of course, as soon as you complete the transaction, get the registration with the Register of Deeds. And then if we're not talking about land, kunwari if it's a sale of a car or jewelry or shoes or other types of movable properties, then it's still better to have it in writing. Pero hindi kailangan na in writing in order to have a
Pero
sale.
grab possession right away.
Get it right away.
Yan ang importante. Pag movable property, no?
Yeah.
It's a car, get it right, drive it away.
Yeah, so
right
you
away.
can protect yourself from double sales.
Don't delay in possession. Kasi sa movable property, importante yung possession. That's the most important thing. All right? So now, we move on. We have received some questions from our guests on topics we have previously discussed, Anne sent us this question. My parents were never married, although in my birth certificate, they said that they were married. That's why I was able to use my father's surname. My parents are separated and I'm staying with my father and stepmother. Does my father need to adopt me? I'm now 20 years old. I guess it depends what she wants,
Yeah.
no? I mean,
Well, in this case, even if the birth certificate says that the father is yung biological father niya, that does not make their marriage legitimate because they were never married. So Anne is still an illegitimate child
she's
of
still-
the father.
In reality, no? Well, here's the thing. In reality, you are an illegitimate child, but at least insofar as that document is concerned,
it's not
though,
sufficient to...
Correct. I'm saying
the
is,
document is not sufficient to prove legitimacy. So because they have to have a marriage contract to prove that, di ba?
Parang
Between the biological parents.
I guess they faked it, no? They faked
The
it.
birth certificate?
Yeah, because they said they were married.
I guess, yeah. In that case, that's falsification of a
Falsification.
public document. But then, and in order for you to get your rights as a legitimate child, especially lalo na kung merong anak ang magkakaroon ng ibang anak yung dad mo, to be safe, maybe you can ask your dad to adopt you so you can get all the rights of a legitimate child from your dad, even if he was never married to your mom. And since 20 years old na siya, kailangan na ng consent niya to be adopted.
Although that will open a lot of, I guess, questions because as insofar as that registration is concerned, you're a legitimate child, iko-question yun. No? The moment you go there and have yourself adopted, there will be a question of, oh, but you are a legitimate child here. So it will be a little bit complicated. It's going to be a complicated procedure. But yes, ultimately, you
Siguro
are a
pwede
legitimate
nilang
child.
simulan with correcting the
Correcting,
birth
yeah.
certificate first
Correct.
before you file for adoption.
Yes. Okay.
We have another question from Kat, which she posted on our Facebook page. Is RATA issued to government officials or employees subject to tax? This is regards to the computation of our withholding tax. So RATA, first, we have to clarify, it's a representation and transportation allowances given to government employees.
And exempt,
yes,
I think under the laws, I think RATA is exempted from withholding tax. Yeah.
It's exempt from income tax. And again, since government employees have an employer, it's up to the government to withhold the taxes. But it should be exempt from income taxes unless it's another given benefit, in which case na pag hindi siya expenses, might be subject to tax. But strictly RATA, it should be exempt from income taxes.
All right. Now, Daphne asks us, if you are employed for less than a year, do you still need to file income tax return? Do international NGOs follow the same set of laws in computing for our income tax return? So there are two questions here. No? One, if she was employed for less than a year, and then the second one is about NGOs.
Even if she's employed for less than a year, she has to pay income taxes. Kasi again, yung general rule, as long as there's a flow of income to a person, regardless kung 1 month lang yan or 2 weeks lang yan, you have to pay income tax. Meaning, if it was last year that you earned some money, even if it's less than a year, you still have to file for an income tax return for this year. And then...
I guess exception na lang would be if you fall within that amount, no? May mga...
if you earned less than 60,000 pesos for a year, you're exempt from the payment of or for filing an income tax return. And then yung question niya for international NGOs, it depends where they're filing the income tax return. If it's an international NGO that does business in the Philippines and they have income here, they're still required to file an income tax return in the Philippines, and they should follow the Philippine tax laws for filing that income tax return.
Right. All right. And
our last question is from Hazel, and she asked, what if both biological parents of the baby to be adopted are dead and the agreement was made between relatives? Can the adoption be considered invalid? What are the steps for us to legally adopt the baby in question?
All right. Well, adopting kasi, it's not just a question of agreement. So here in this case, biological parents have died. The relatives can't just treat this person as like property and then and sort of like have
An
him or her
agreement
adopted.
na,
Yeah,
"Sige, ampunin niyo."
yeah. You have to go through the
Yeah.
process na, and it normally involves the DSWD. Di ba?
Yeah.
So,
And there has to be a court order declaring the child as available for adoption.
Yes.
It's not up to the relatives to say that because the child is now an orphan, pwede na siyang ampunin. So there has to be a court order declaring the child available for adoption, and then whoever wants to adopt that child has to undergo the process for adoption. They have to go to court for that.
even if the biological parents are alive, the parents can't just have an agreement. You know, again, you have to go through that process. It's a court process. So yan, just want to remind. Kasi it's quite common in the Philippines na minsan agreement lang na parang, usapan lang natin, we'll papa-adapt namin sa'yo. So we try to avoid that as much as possible. All right, we'd like to take this opportunity to thank all our viewers who sent us their questions via social media. We'd also like to thank our guests who joined us earlier tonight in discussing your legal rights on double sale. I'm Attorney Rod Nepomuceno.
And I'm Attorney Karen Jimeno. If you have any questions on our topic for tonight, you may share them with us on our Facebook and Twitter pages. If you've missed any episodes of Legal Help Desk, you can watch these on your mobile devices at your convenience. Download the Solar News mobile app on Google Play or Apple App Store. Join us again next Monday as we discuss your legal rights. Good night.